So I'm going to talk about human rights and speciesism, just to give you a little bit of background as to why I'm talking about that. My first job was actually as a lecturer in human rights. So after the PhD, I was appointed as a lecturer in human rights at the LSE in London, and I was really pleased. I got a job, and it was great to teach human rights. A lecturer in human rights, that was fine. Yeah, I did my PhD on animal rights, but I was into human rights too, obviously, right? Like I was into social justice, and humans have rights as well, right? And I was a rights theorist, so it made sense to take that job and to do, cartwheels and high fives, having got it. But it was really interesting as I started to work in that job. Some of the resistance I was getting from students. The students, I should say, were amazing. You mean the students deserved better than me? At one stage, I was teaching the Director General of Amnesty International in Pakistan or something, and it was like, I'm not sure if this guy needs to hear about Hofeldian incidents, right? Like, I'm not sure if this is doing him much good. But the students were great, but they were a little bit resistant when I started talking about animals or the human behind human rights. And not just resistant in terms of that's not what we're interested in, but resistant as in actively hostile of raising the animal question when dealing with human rights. And that was a long time ago now. It was my first job, so it was some decades ago. But that kind of tension between human and animal rights has kind of stayed with me, and it's always intrigued me. And then I was asked to write a chapter for a new handbook that's coming out on human rights, and to write a chapter on speciesism in human rights. And I was like, fantastic, this is great, because this is a very conventional human rights handbook. So I'm really pleased to contribute a chapter on animals to it. I'm always interested in taking the animal issue to audiences who perhaps aren't thinking about it enough. So I was really pleased to address that issue of human rights and speciesism within the chapter. And that's the paper I'm going to present today. Are human rights speciesist? So it's not just a question of is there some possible kind of slight tension between the two, but are human rights actually doing something wrong? Are they doing something problematic when it comes to protecting the interests of animal? So let's start then with just some clarifications of what I'm talking about. When it comes to human rights, I take a massive broad approach to what human rights are. So by human rights, I mean those moral, legal, and political claims and practices used by various actors to specify the basic entitlements of all human beings. So they're moral, they're legal, but they're also a political practice. So I'm also interested in the legal and political practice of human rights, not just these kinds of moral and legal entitlements. I'm interested in the institutions as well. Speciesism requires a little more elaboration, but broadly, speciesism is the disadvantageous consideration or treatment of those who are not classified as belonging to a particular species. The term, many of you will know, was coined by Richard Ryder back in the 70s, but then popularized by Peter Singer in Animal Liberation. And Peter Singer used the term to draw analogies between the treatment of animals and the disadvantageous treatment of women and of racial minorities. So on his understanding, sexism is the prioritization of the interests of men over women simply because those interests belong to men. And racism is the prioritization of the interests of white people over racialized minorities simply because they belong to white people. So for him, and this is the view I take too, speciesism then is the prioritization of the interests of humans over non-humans simply because they belong to humans. Okay, so that's what speciesism is, and that's the understanding I'll take. So the question for today, the question in this paper is, are human rights, this set of moral, legal, political claims and practices, do they prioritize the interests of human beings over and above those of other non-human animals in an unjustified way? So that's the question I'm going to ask today. Okay, and here's how we're going to do it. So first of all, I'm going to look at the claim that human rights are speciesist. But so what? Maybe human rights are speciesist, but that's fine. That's good. And I think this is an important claim to address because it's a conventional claim. Nearly all my colleagues in my department back in Sheffield think this view, right? And I keep telling them they're wrong, but they keep telling me I'm wrong. So it's important to address this head on. Human rights are speciesist, but that's just not a problem. I will argue against this and say the speciesism of human rights is a problem because all sentient creatures possess morally important interests and on an equal basis. Okay, so I'm going to argue against this view. Then I'll look at the idea that human rights need not be speciesist if we institute a set of non-human rights. So something akin to what the Non-Human Rights Project are trying to do. So if we could get some fundamental set of animal rights into a constitution or into some political mechanism that sits alongside human rights, maybe even we could get them internationally, wouldn't that be amazing? But if we can get animal rights like in there, in our legal and political machinery, just like human rights, then human rights need not be speciesist. They can be considered on an equal footing. I think that's a really noble ambition, but I'm going to raise some questions about whether that would actually overcome the speciesism of human rights. And in section 3, I'm going to point out some challenges to the effectiveness or the possible effectiveness of non-human rights. And I'm going to draw on some feminist literature surrounding women's human rights and show why having a separate system, a distinctive system of legal and political claims can sometimes lead to a downgrading of the interests of that other group. So then in the final section, I'll claim that what we need to do is rethink human rights from the bottom up. We need to transform human rights. We need to deconstruct human rights. We need to build something new that's not human rights or is human rights plus, but it's actually sentient rights. So I'm going to put forward a view, which I've put forward in previous papers and books, arguing in favor of something called sentient rights. And it's only by having this shared new set of sentient rights that we can really overcome the speciesism of human rights, or so I'll claim anyway. Okay, so that's what we'll do today. So let's start then with this idea, an important idea, I think, because it's so prevalent, that human rights are speciesist, but this just isn't a problem, okay? Human rights are speciesist, but so what? Let me start, though, just by looking at the idea that human rights are speciesist and why they might be speciesist. Let's just focus down a little bit on why human rights might be considered to be speciesist. Well, human rights are usually regarded to have a certain priority, not just in our moral, but also in our legal and political practice. Human rights are of special importance. So if human rights are being systematically violated within a state, then it's widely accepted that this is of urgent concern to the international community as a whole. Indeed, some authors even define human rights in these terms. Human rights are essentially triggers for intervention. Okay, what intervention means is disputed. It doesn't mean send the tanks in or send the military in, but intervention in terms of get involved, tell off that state, engage some diplomacy, if you like. And that's quite unusual. You know, states, because of state sovereignty, usually stay out of one another's affairs, right? The right to self-determination means that I can't come to Helsinki and start telling you guys off for it being too bright at 9 or 10 o'clock at night, right? That's nothing to do with me as a UK citizen. It's up to you to decide. Well, it's not actually, it's the laws of physics, isn't it? But there's certain things that are up to you to decide as a self-determining nation. But when it comes to human rights, it's not just up to states for themselves to decide. Every state should be upholding and protecting these human rights. So that shows that they have this urgent priority. Animal claims, however, just don't have that kind of urgent priority. There are no animal claims that have that type of special status, if you like. So it seems then that human rights, The fact that humans have instituted this set of urgent political, moral, legal claims, but not instituted anything for animals, seems to suggest that human rights are, on their face, speciesist, okay? But maybe that's perfectly reasonable. Perhaps there's good reason that we've done that as human beings. Perhaps it's perfectly reasonable because of something which has been described as human supremacism, right? Perhaps human supremacism is true. Humans are just more morally important than any other creature on Earth. Why might people claim that? Well, a few different views have been put forward in the literature, and I'll just survey them now briefly because I'm sure that many of you are aware of these. But I think there's three kind of broad groups of arguments in favor of human supremacism. The first one is that humans are of special moral importance because they're humans. That's the argument I hear the most often. I find it hard to kind of compute because it just sounds kind of circular and nonsensical. Humans are of special moral importance because they're humans. But then you go, well, why? What is it about humans? And the response, and this is a response put forward by people who are far cleverer than me. Bernard Williams puts forward this view, Anne Phillips puts forward this view. But the claim is we don't need to provide any reasons. Humans just denotes a category of special moral beings. It is a moral category in and of itself. Humans are special because they're humans. Humans means a higher moral status. And in fact, it's interesting that this view has also been advanced and proposed in some very recent works on human dignity and human rights, recently by Andrea Sangiovanni, Jeremy Waldron, and so on, who look at what's special about human beings. The problem, though, is that this view simply asserts what needs to be justified. It may well be the case that many people in contemporary societies employ humanity to denote this special status, and lots of people do that. I'm not sure about here, but in the UK media, we do talk about the human community and the human family and our fellow humans, and it means special moral importance. But that doesn't make that usage morally correct. Indeed, the fact that many societies employed, and continue to employ, male or white as denoting special status did not and does not make that usage morally justified. So instead, we need to dig behind that usage and see if there's any basis to it. And so for that reason, some people have offered reasons for why humans are of this special moral importance, and they usually rely on something to do with humans' special cognitive powers. There's something important, uniquely important about us because we have moral autonomy, we can make moral rules, we can live by our own morals, we can pursue a conception of the good, we can decide who we want to be in life, we can choose to worship God or to drink beer or to, whatever we want to do, we can decide to do it. We have this free will, this moral agency that other creatures don't have. Of course, this view, as popular as it is, has been widely critiqued in the animal ethics literature. I'm sure you'll be aware of those criticisms, because the fact is, not all humans have those capacities, young infants, for example, being a really good example, and some non-humans might actually have those capacities. So if you start looking at the literature on great apes or cetaceans, you can start to see that they might have elements of this kind of agency. So this is the argument of species overlap, that there's just not these clear lines. All humans have this and all non-humans don't. So then for this reason, and this is the third set of arguments in favor of humans having this unique special importance, some people have put forward the view that it doesn't matter what specific individuals have in terms of these cognitive capacities. What matters is what group you belong to, So young infants might not have these super cognitive capacities, this factor X, whatever it is, but they belong to a group, human beings, normal human beings, which does have those capacities. And this is another view that's really prevalent when I discuss these matters with non-animal people. They are animal humans, but you know what I mean by non-animal people. So the problem with this view, however, is picking a group is quite an arbitrary exercise. If you're going to award status to an individual based on the group to which they belong, which group are you going to pick, right? It could be all those who have short hair, who have long hair, who are short-sighted, who are long-sighted. It could be all those who are living creatures, or you could go by phylum, or you could go by all sorts of other biological categories. Why pick the species as the biological category? It seems arbitrary. And in any case, even if we said that humans, species, is the right group to denote status, then why should we regard normal as what belongs to certain adults within that group? Because, of course, it's perfectly normal for young infants not to have those characteristics. They're not kind of weird outliers, exceptions to the rule. There's quite a lot of young infants, for example, in the human population. There's quite a lot of individuals. It's perfectly normal for human individuals not to have these cognitive capacities. So there's some of the problems with awarding special status to individuals based on the group to which they belong. So these arguments, I think, all reveal the huge difficulty in trying to defend the claim that human rights are justifiably speciesist because human supremacism is justified. The human supremacism that human rights is built upon is really hard to sustain. And if you don't believe me, go and look at all the books on human rights that deal with the foundations of human rights. Human rights philosophers are still tearing themselves up over what is the foundation of human rights. What's so interesting is how few of them are dealing with the animal question as part of those debates, right? That is really just interesting to me. So that human supremacism is hard to justify. But none of this is to say that we should be skeptics. My view is not that human beings do not matter. My view, instead, is that humans do matter and they do have these special entitlements called human rights. But human beings matter and matter profoundly for this reason, in my view. And this is not some amazingly new novel claim that I came up with and will be cited forever. This is a claim that comes from lots of other authors too. Human beings matter because they are vulnerable beings who possess a life that can go well or badly for themselves. Put simply, human beings have morally important interests. Interests that matter to themselves, and therefore interests that matter to all moral agents, or interests that should matter to all moral agents. Now, crucially, human beings are not the only creatures on earth with interests. Human beings are not the only creatures who have lives that matter to themselves. All sentient creatures, including many non-human animals, also possess them. So just as it is wrong to prioritize the interests of certain groups based on biological characteristics like sex, or like race, or like long hair, short-sighted, long-sighted, it's wrong to prioritize them on the basis of species. Okay, there doesn't seem to be any reason why we should start discriminating between the groups of beings with interests, given that they all have those interests. So if human rights are speciesist, then so much the worse for human rights. Okay, so there's a problem here. But maybe we can solve this problem. Let's try and solve it. Maybe human rights need not be speciesist. And I think this is a route that's taken by many scholars and many activists at the moment. And like I said, I think it's a noble endeavor, even though I'm going to criticize it. So while it seems correct that human rights currently denote the most pressing and urgent moral, political, and legal claims, it's not clear that this is inevitable, for it seems at least possible for societies to recognize and protect a set of non-human rights that protect the basic entitlements of non-human animals. And if these non-human rights were awarded an equivalent status to human rights, then hooray! We wouldn't have a speciesism of human rights. We wouldn't have a prioritization of human interests. But maybe we don't even need to do that. Maybe we can give animals the respect they deserve, the respect they are due, without even having to award them rights. Maybe animals don't need rights. Maybe we can consider their interests equally and reasonably without the award of rights. And this kind of approach is appealing to those who are a bit skeptical about animal rights because animals can't claim them on their behalf. I don't think personally we need to worry about animals' inability to claim rights on their behalf. I follow along with lots of other interest-based rights theorists the view that really comes from Joel Feinberg's famous paper back in the 70s, that what matters really to the attribution of rights is the possession of interests. And as long as you have interests, then others can claim rights on your behalf, even if you perhaps can't claim them yourselves. And I think that this is how certain interests of animals are protected in the real world. What Saskia Stuckey has referred to as simple legal rights. Hi, Saskia.
It looks like Saskia, it's not Saskia.
All right. Sorry. Hi, Saskia on the internet. But these simple legal rights aren't fundamental. These simple legal rights aren't fundamental legal rights. Fundamental legal rights are ones which are more profound, which are more constitutionally protected, ones that are perhaps entrenched within a political and legal system. But anyway, the point really is simply to show that animals can have rights, even though they can't claim them themselves. But it doesn't just make sense conceptually to award rights to animals. It's also good for animals themselves. And I think there are three reasons why it's important, normatively important, morally important for animals to have rights. And these come from, these three reasons have been put forward by William Edmondson in a paper as to whether animals need rights. The first reason why animals might need rights is to do with their important protective function. This is the most obvious reason, right? So animals need rights in order to be protected, to have their interests protected. And rights act as firewalls, side constraints, and trumps, there's the classic Dworkinian phrase, on the pursuit of overall welfare. So societies want to maximize welfare, they want to think about the greater good, they can't individuate very easily. Rights guard against trampling on minorities, trampling on individuals by providing these protections. So they serve that important protective function, and animals would benefit from that. Second reason Edmondson puts forward is that rights also have a generative function. A generative function. So once you acknowledge that someone or something is a rights bearer, that can lead to a certain respect being awarded to that individual. And once that respect is afforded, then they might get other rights. Okay, so once you start giving them rights to X or Y, respect is due to them, then you might start giving them rights to Z. Okay, so rights have this important generative function, and you can see why animals might benefit from that. You know, one minute people are talking about rights to life for animals, then some people come along and start saying crazy things like, let's have labor rights for animals, right? And this is an important kind of generative function that rights awards can have. Finally, rights serve an important fallback function, according to Edmondson. This is very close to the protective function, but still, we'll forgive him that. The point here is that as enforceable claims, rights offer protections to individuals even when those individuals might not have much sympathy within a society or might not have much concern afforded to them within that particular society, right? So this is why we think it's really important for human rights to be afforded to migrants or to prisoners, for example, those people that perhaps marginalize in a society. It's important that they have that even when they're not shown much sympathy. That's going to be really important for animals too, given that so many of them are vilified as, pests or vermin or as overpopulated, right? It's going to be important for them to have this fallback function. So, in summary, it's possible for animals to have rights, and it's morally important for animals to have rights. So it seems then that we can get over the speciesism of human rights, and we should get over the speciesism of human rights by awarding, assigning, and protecting a set of non-human rights, a set of not simple, kind of rubbishy legal rights, but fundamental non-human rights that are on an equivalent basis to human rights. That could be the end of the paper, but it's not, okay? There's some problems, I think, with this view. And this view, like I said, is admirable, and the Non-Human Rights Project have been advocating for it in the US for a number of years now, and I'm sure you're all familiar with it, and more familiar with me in terms of the details. But I take them really as the paradigm example of this kind of approach. If we can get non-human rights into statute books, into the law, then we can set up a system of rights that's equivalent in terms of protecting the interests of some animals compared to others. What are the challenges to effective non-human rights, however? Well, obviously, this is an easy one. Institutionalizing a set of animal rights de jure provides no guarantee that they will be regarded as equivalent to human rights de facto. That's kind of obvious, but I think it's also important to explain. Because even if a society attempts to institutionalize a set of robust protections for animals, it's important to realize how strong the pressures will be, the economic, the social, the cultural pressures, to water down those protections. And I think this is really illustrated by what's happened with constitutional protective provisions on behalf of animals around the world. I know Jess is going to speak about this tomorrow. Various countries have instituted constitutional protections for animals: Austria, Brazil, Egypt, Germany, India, Luxembourg, Slovenia, Switzerland. And they aim to give animals far more robust protection than traditional animal welfare law. Indeed, their point, in many regards, has been to mitigate the flaws of ordinary animal welfare law. This really comes out in the German case, as many of you will know, where really it was the problems with animal welfare law in the face of human rights law that led to this constitutional provision. So there's a very famous case that I'm sure many of you are aware of from 1994, where a researcher in Berlin sued when he was denied a permit to carry out experiments on monkeys. He wanted to sew shut the eyes of newborn monkeys for a year, then tie them to a primate chair for up to 6 months while making them do visual exercises. He was initially denied the permit on animal welfare grounds, right? That seems understandable. But this decision was overturned by a higher court because it violated a constitutional right to freedom of research. So we see here how there's a tension between the animal welfare law and the human rights, and it was that tension that led to, or was part of the reason why constitutional protections of animal interests came into existence. So, to try and lift up animal interests to a more equivalent basis to human interests, we could enact these protections constitutionally, and we have done. But we've also seen that these protections have been lacking in teeth when it comes to really protecting the interests of animals. And for example, consider the case of crushing or gassing male chicks in contemporary egg production. German animal welfare law prohibits the infliction of pain and death without reasonable cause. For some, this would seem to rule out killing male chicks, which is obviously not necessary to egg production, but instead it's carried out for economic reasons. But when the authorities attempted to ban the practice, a higher court ruled that animal welfare laws allow for the slaughter of animals and the gassing and the crushing of animals if there are sound economic reasons to do so. So in spite of the constitutional protection, it was very easy to downgrade, to overcome, to subordinate the interests of animals, even in a case like this. So such rulings illustrate that even when constitutional provisions are in place to protect their welfare, animal interests are easily subordinated to the economic interests of human beings. Now, of course, it can be legitimately pointed out that these are constitutional protections. They're not, non-human fundamental rights that are equivalent in status to human rights. And that would be a good response. They're more akin to the kind of simple legal rights I was talking about earlier. So perhaps we should just kind of ignore all that contemporary bad practice, if you like, and aim for establishing real fundamental non-human rights. More than go beyond constitutional provision. But while that's possible, I think that is possible, I think there's reasons to doubt that that would lead to the protection of animal interests on an equivalent basis to humans. And the worry that I have is the separation of these animal rights, these non-human rights, from the rest of the human rights regime, if you like. The concern is that even if a society decided to enact a set of fundamental non-human rights that were intended to be of equivalent weight and urgency to human rights, their distinctiveness, their separation would lead to a subordinate status in reality. The reason for this worry comes in part from the example and experience of women's human rights in the international human rights system. And here I'm really, leaning on is charitable, but just taking the analysis of Hilary Charlesworth to inform me. So, of course, the International Bill of Rights, which is the Universal Declaration of Human Rights, together with the two international covenants on civil and political rights and economic, social and political rights, they obviously included women in their scope of rights, of course. However, it was understandably felt back in the 70s when these came into force that these did not target the specific human rights abuses and experiences of women in particular. As such, there was a big campaign to get something new and targeted at women and their particular experiences of human rights abuses. And this led to CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, which was adopted in 1981. However, this separation of women's rights from the rest of the international human rights regime has been controversial, and Charlesworth has been critical. And she actually claims that it has led to a subordinate status for women's human rights. And I'm quoting her now. The price of the creation of separate institutional mechanisms and special measures dealing with women within the United Nations system has typically been the creation of a women's ghetto, given less power, fewer resources, and a lower priority than mainstream human rights bodies. So why would that be? Why would setting up CEDAW actually lead to bad effects for women? Well, the idea is that women's human rights are being ghettoized as a result. So when the other human rights committees are sitting, they feel they don't need to engage with women's experiences or deal with the rights of women, because that's for CEDAW, that's for those other people down the corridor, that's what they deal with. We can just get on with the real human rights while they deal with the women's ones down the road. Now, this subordination is unlikely to be intentional. The actors, no doubt, feel justified in largely ignoring women's issues because they think they're being taken care of by others. But it's still there nonetheless. So the concern is that any attempt to institutionalize a set of non-human rights, whether that be domestically or internationally, would meet the same kind of fate, the same kind of ghettoization fate. Now, a legitimate response to this worry would be, well, let's not have a separate set of animal rights, then let's redefine human rights to include animals, just expand the notion of the human. That kind of might seem kind of nonsensical, but the human is a fluid concept. It's been narrower and got bigger, so let's make it bigger to include animals too. But again, the experience of women shows the problems with this particular view. The history and practice of women's human rights provides lessons. Because the problem of the ghettoization of women's human rights is not resolved by simply absorbing them back into human rights. This shouldn't be a surprise, right? CEDAW was set up even though women were included in the international human rights regime, right? They were responding to the ineffectiveness of traditional international human rights instruments. So feminist legal scholars pointed out that human rights had built into them a male bias. They were built on a male perspective. And the classic example of this, of course, is the attention and priority afforded to civil and political rights. Freedom of assembly, freedom of speech, the right to a fair trial, and so on. These provide individuals with protections in the public sphere from the state. But they bake in the prioritization they've been given, and that prioritization is evident in the fact that the committees at the international level have more teeth. The prioritization is evident in the fact that the European Convention is only civil and political rights, right? That prioritization is absolutely clear. But that prioritization has baked in a problematic public-private distinction. Put simply, they entrench the idea, or that prioritization entrenches the idea, that the most grave and most urgent threats to our human rights come from the state in the public sphere. Obviously, this means that human rights fail to address the most serious threats to half the human population. And just quoting again from Charlesworth now, from conception to old age, womanhood is full of risks, of abortion and infanticide because of the social and economic pressure to have sons in some cultures, of malnutrition because of social practices of giving men and boys priority with respect to food, of less access to healthcare than men, of endemic violence against women in all states. End of quote. So, in light of this analysis, these feminist scholars have rejected both the establishment of a distinctive set of women's rights on the grounds that it leads to ghettoization and the protection of women's human rights through mainstream human rights instruments on the grounds that it leads to this male bias. Instead, then, they propose that we seek to overturn the male bias of human rights and redefine human rights, rethink human rights from the ground up. And that includes having a more diverse perspective on what those rights are.
About 8 minutes.
Thank you. So, just as women's rights are not best protected when they are simply added to human rights and stirred, but are actually used to transform and challenge the assumptions behind human rights, perhaps the same should be true for non-human animals. So we need to redesign both human and animal rights in such a way that the former are not always privileged. So the aim would be to find some mechanism by which both could enjoy fundamental normative protections, symbolizing the equal interests, the equal value of the interests of those who possess them. And that redesign and transformation of human rights is something that we've done before. After all, the way to overcome the sexism, racism, classism, and nationalism of previous notions, such as the rights of man, was not to institute separate rights for women, for racialized minorities, for the non-propertied and foreigners. Instead, it was to affirm the equal rights of all human beings through human rights. So my claim is that we should redesign and transform human rights now to include the legitimate claims of all sentient creatures. That's the claim. So we should move from human rights to sentient rights. Okay, and I'll just end now by fleshing out that proposal, and I think that'll be okay. There's no screams.
Can you close the door, please?
So I've already argued that prioritizing the interests of human beings simply because they belong to humans is not only speciesist, but morally wrong. There is an equality amongst all sentient creatures, which means that we ought to consider the interests of sentient individuals equally. Species membership alone is not a legitimate grounds for privileging one group over another group. So it makes sense, but it's also normatively important for non-human sentient animals to be recognized and respected as rights holders. All sentient creatures, whether human or non-human, possess certain basic rights because they possess certain basic interests. Crucially, these rights serve important protective, generative, and fallback functions. So I'm repeating what I said now, but it's important to show how these reasons apply to all sentient creatures, human and animal. I'm not just talking about animal now. Those reasons apply to all sentient creatures. And that provides a really strong prima facie reason to move to this new understanding of sentient rights. We all, the new community, the new community of moral worth is sentient creatures. So that provides a really strong reason to move to this new understanding of sentient rights. And that would have a real advantage in overcoming some of the hierarchies that human rights both symbolize but have also helped to foster. Human rights have human supremacism baked into them, but they also promote that human supremacism. You know, they normalize the idea that humans and their claims are of this special moral priority and importance. So moving towards a scheme of sentient rights would have that important role in countering that supremacism. Overturning those assumptions by establishing a set of non-human animal rights with equivalent weighting is a noble step. So those proposals by the Non-Human Rights Project are noble, but I do worry that they're not going to be quite enough because of their separate and distinctive status. So I think we need to rethink things in terms of sentient rights. Now, there are some objections to moving towards sentient rights, redesigning human and animal rights under this shared umbrella term of sentient rights. So what are they? I'm just going to point to two before we finish, and then you can tell me some more afterwards in the Q&A. But the first one is that, look, human and animal rights aren't the same thing. Animals have certain rights, not to suffer, to be free, rights to habeas corpus or whatever. Humans have certain rights, like to get married, to a fair trial, to vote and so on, that just aren't applicable. So they're two different things. So we can't have them under this umbrella term of sentient rights. Well, my response to that is, first of all, there are some shared ones, and perhaps more shared ones than we might have assumed. Like I said, it's not just liberty and not to be killed anymore. There's other things too, like, well, perhaps democratic participation, labour rights, exciting new avenues that I'm sure you're all pursuing. So there are more shared ones than we think. But also when it comes to human rights, different groups of humans have different rights, right? So women have certain rights that men don't have. Children have certain rights that adults don't have. Adults have certain rights that children don't have. Indigenous groups have certain rights that non-Indigenous groups don't. So that's all fine. They all make sense under an umbrella of human rights because they all have a shared normative basis, protecting individuals in leading a decent life, and they also have a shared purpose in terms of protecting individuals, giving them a fallback and having that generative function, right? And the same is true of sentient rights. They all have that same grounding in allowing individuals to lead a decent life, and they can serve the same purpose. The content, a differentiated content, doesn't matter to unifying them under this shared term. A second challenge is that some people will worry that if we're going to have all humans and animals under this umbrella term of sentient rights, humans are going to sometimes lose out, right? Humans are going to lose out. And that could be seriously problematic to how we do things in society. The first response to this is, yes, sometimes humans are going to lose out. That is inevitable. There are going to be clashes of rights. We are going to have more rights holders than we perhaps first realised, and they are going to need to be, when those clashes occur, we're going to need to balance the interests on an equitable basis, and that may lead to humans sometimes losing out. But it will lead to them losing out when it's in a justifiable way. So humans aren't going to win because they're humans. They're not going to lose because they're humans. They're going to win or lose depending on the strength of interests. Because when rights clash, what we ordinarily do in legal and political machinery is look at the interest underlying the rights and see which is weightier. And we'll have to do the same when it comes to human and animal rights when they clash. And when the human interest is weightier, that will win. But when the animal interest is weightier, perhaps that will win. Now, the usual response I have to this is, does that mean then that a rat's right to life is going to trump a human right to life? Okay? That could be seriously problematic for how we run our societies. My response to this is, while we weigh interests equally, we need to look at the basis of the interest. And when it comes to the right to life, I think there are reasons to think that in most ordinary cases, humans have a stronger right to life because it's grounded in an interest that's stronger compared to rats. And that's because of our ability to project into the future, to make plans, as well as our interests in community life, family life, and so on and so forth. That's not because we're humans, though. It's not based on a human prejudice. It's based on the kinds of interests that we have as individuals. So that's my response to that. Okay, just to conclude. In this paper, I've considered whether human rights are speciesist. That is, whether they prioritize the interests of human beings over those of all other non-humans. I've pointed out that in current practice and theory, they really are. But I've also argued that speciesism can't be justified because human supremacism is not justified. All sentient creatures merit equal consideration of their interests. While it's possible to avoid speciesism through instituting a set of non-human animal rights that would be equal in weight to human rights, I've pointed out that there's actually some real challenges in doing so. And looking at the experience of women's human rights in the international human rights regime points out that there could be dangers in doing so. Instead, then, what I've proposed to really overcome that speciesism is what we should do is reconceptualize in theory and in practice human and animal rights, reconceptualize them as sentient rights, and that would offer a way for communities to genuinely offer equal consideration to the interests of all sentient creatures. Thank you very much.